much. I thank all the attendees, and I give a special thanks to my dear sister, Professor Dr. Iman Draz, is the pacemaker of this visit. And also I welcome Professor Dr. Mona for her attendance and to share us and to exchange our knowledge with the Department of Forensic Psychiatry and Toxicology. I will start my lecture by some repeated statements mentioned by Dr. Allen about what is forensic psychiatry. Forensic psychiatry as a new maybe services in our department. What is forensic psychiatry? Forensic psychiatry is a branch of medicine which focuses on the interface of law and mental health. It may include psychiatric consultation in a wide variety of legal matters, like expert testimony, clinical work with perpetrators and victims. What is a forensic psychiatrist? A psychiatrist is a medical doctor, qualified, who has completed several years of additional training in the understanding, diagnosis, and treatment of mental disorders. A forensic psychiatrist is a psychiatrist who has additional training and/or experience related to the various interfaces of mental health or mental illness with the law. How is forensic psychiatry useful to legal process? When legal matters involve issues outside lay expertise, lawyers and judges regularly seek consultation from professionals in a wide variety of fields, including medical specialties. Such professionals are often called experts or expert witnesses. The criteria for expert designation in such cases are legal ones and not necessarily scientific. The best possible information can be offered by such experts to judges or juries, attorney or other party who may request consultation. Forensic psychiatrists may be involved with criminal matters, civil litigation such as malpractice lawsuits, competence to do things like make a will, consent to medical care or take care of children, child custody, treating and working with mentally ill people who get in trouble with law, helping victims of crimes, helping lawyers and judges understand the psychological aspects of their cases. Here are three things they are not. A forensic psychiatrist are not lawyers. A forensic psychiatrist are not judges. A forensic psychiatrist are not cops. We are not lawyers. We may work with lawyers, but our job is to be good doctors who can translate what we know into something useful for the legal system, not to be lawyers ourselves, even if we have a law degree. We are not judges. We don't interpret the law or tell judges or juries how they should rule. Most of the time, psychiatric issues are only a small part of the entire legal matter. That is to help the judge or jury decide not to tell them what to do. We are not cops. We are not who protect the community, deal with the dangerous or criminal situations, or contain the bad guys. That's not our area of expertise. Are forensic psychiatrists advocates for one side or the other in legal matters? Usually not. Ethical forensic psychiatrists try to avoid bias. They focus on the data or evidence within their areas of expertise and comment objectively on the information as they see it. Ethical forensic psychiatrists do not accept contingency fees or otherwise conduct themselves in ways that may interfere with or imply a lack of professional objectivity. Ethically, experts are paid for their time, not their testimony. Since the time spent forming the opinion usually far exceeds time spent testifying, most payment is received regardless of whether or not the expert testifies. Forensic psychiatrists are similar to most other professionals in their respect of their work and their clients. The minority who cheat in some way risk severe censure and loss of credibility. Presence of forensic psychiatry facility as an essential part of mental health services aims at: there should be no mentally ill in prison, to provide a comprehensive rehabilitation and to reduce recidivism. recidivism الانتكاسة أو العودة للفعل تاني اللي هو كان committed يعني. It might be prison based، في بعض الأماكن بتبقى prison based. It might be hospital based. And we should stress that the therapeutic principle is applied in a judicial process. العملية العلاجية تتم من خلال عملية قانونية قضائية أكتر يعني. We should highlight the issue of competency and capacity. Capacity is the ability to understand information relevant to a decision and to appreciate the reasonably foreseeable consequences of a decision or lack of a decision. Capacity refers to an ability. That's to say, having capacity. Capacity comes in degrees. Competence refers to a property or characteristic a person possesses. That's to say, being competent. Competence relative to a particular decision is all or nothing, don't have degrees. So when we define capacity and competence, we can say that capacity is a degree to which one is able to understand the information relevant to a treatment decision and appreciate the reasonably foreseeable consequences of a decision or lack of a decision. But competence is being able to understand the information also relevant to a treatment decision and to appreciate the reasonably foreseeable consequences of a decision or lack of decision. Regarding capacity, capacity is specific to a particular decision. A person may possess the capacity to make some decisions but not others. Capacity can change over time, like in delirium, drugs, course of illnesses, and treatment. If you are worried about patient's capacity to refuse some treatment, you should also worry about his capacity to accept it. Why does capacity matter? Two kinds of reasons: moral and legal reason. The moral one, capable patients are by definition able to give informed consent. The importance of informed consent is supported by both by the principle of autonomy, the principles of beneficence, non-malfeasance issue. The legal reason, in law, capable patients entitled to make their own informed decisions. If patient is incapable, physician must obtain consent from a designated substitute decision maker. Presumption of capacity for adults and for minors, check provincial legislation on mature minors, Child Welfare Act, etc. Aids to capacity assessment. We can assess capacity through different means: general impression of capacity from clinical encounter, cognitive function testing like many mental state examination, and there is many specific capacity assessment tools. Each institution has its tools which is approved, which is validated, which is implemented in each institution. Many mental state examination, we all know that it is a very simple test. It is reliable, easy to administer, and familiar, but its problem, although cognition and capacity related, they are not identical. Does not evaluate several cognitive functions like judgment, reasoning that are relevant to capacity, and does not address delusions, for example. There are 7 areas to consider when you assess capacity. Ability to understand medical problem. Ability to understand proposed treatment. Ability to understand alternatives, if any. Ability to understand option of refusing treatment. Ability to appreciate reasonably foreseeable consequences of accepting proposed treatment. Ability to appreciate reasonably foreseeable consequence of refusing proposed treatment. ability to make decisions not substantially based on delusions or depression. There is another related issue, which is competence to stand trial. In court trials, it is a very important issue to judge competency of the accused person. There is a term which is called adjudicative competence, the legally determined capacity for a criminal defendant to proceed with criminal adjudication. The terms adjudicative competence, or competence to proceed with adjudication, or competence to stand trial, also fitness to stand trial, are all used interchangeably. This adjudicative competence has two aspects. Competence to assist defense counsel. This encompasses the defendant's ability to understand criminal charges, the implications of being defendant, the adversarial nature of the criminal proceedings, and the role of defense counsel. Competence to assist also includes the defendant's ability to work with and relate information to defense counsel. The second aspect is the decisional competence. Refers to the ability for the defendant to participate autonomously in making decisions that arise in the course of adjudication, whether to testify, whether to plead guilty, and if the case goes to trial, what strategy should be used. Mental states interview, including history, mental states examination, psychometric tests if needed. And also we should have what's called collateral data, information that comes from sources other than the defendant's statements during the psychiatrist interview. Such sources include police reports, medical records, statements by the defendant's attorney, and reports from the defendant's family member. In formulating an opinion about the adjudicative competence, اللي هو الأهلية للعملية القضائية يعني, the psychiatrist usually consider three questions. Number one, what symptoms does the defendant have, and what is the defendant's psychiatric diagnosis? Number two, what is the relationship, if any, between the symptoms of diagnosis and the mental capabilities required under the adjudication's standard for competence to stand trial? The third one, if the defendant appears incompetent to proceed with the adjudication, how likely it is the appropriate restoration services would restore his competence, and what is the appropriate least restrictive settings for such services? There are many instruments to examine competency. Competency assessment instruments, CAI, not CIA. Georgia Court Competency Test, interdisciplinary fitness interview, and competency screening tests. These are all good examples of how to examine competency in such patients. There is some summarized highlights of each instrument. Competency assessment instrument used for assessing competency defendants with suggestive findings. It is a structured interview, and these are the 13 functions of the CAI. It includes appraisal for available legal defenses, unmanageable behavior, quality of relating to attorney, and so on. This also the Georgia Court Competency Test. It is 21 questions, and this is a summarized presentation of this test. The interdisciplinary fitness interview, also a semi-structured interview, and this is a summary of this interview. Lastly, the competency screening test, the 22-item sentence completion task designed as an initial screening test, and so on. Another issue is there is two related terms, the insanity versus competence. Insanity relates to the defendant's mental state at the time of offense occurs. Competence refers exclusively to the defendant's mental abilities at the time of the proceeding. An insanity defense is based on the theory that most people can choose to follow the law. But a few selected persons cannot be held accountable because mental disease or disability deprive them of the ability to make rational voluntary choice. There is a definition of mental illness and mental disorders in law. ويمكن دي يمكن الدكتور هشام يتفق معايا ان وصف الامراض يعني بصوره الى حد ما مش مظبوطه شويه، يعني بيحبوا قوي لفظ كلمه المريض العقلي او الاعاقه الذهنيه او الجنون او ما عندهمش برضو يعني محتاجه نوع من التطوير بالذات. وانا سمعت يمكن اعتراض من الاستاذ الدكتور احمد عكاشه على الحته دي بالذات، ان وصف المرض النفسي في القانون ما هوش برضو واخد الشكل اللي احنا نرضاه يعني. فهم يعني mental illness of such a severe nature that a person cannot distinguish fantasy from reality, cannot conduct his or her affairs due to psychosis, or is subject to uncontrollable impulse behavior. Legal standards for insanity. في McNaughton rule و Durham rule. الأولاني states that in order to establish insanity, it must be proven that at the time of a crime, the accused had a mental defect, such as a mental disease, or that she, he, or he did or could not know the nature or quality of their crime at the time of offense, or if the accused did not know that what she or he did was wrong. The Durham rule states that the accused is not criminally responsible if his or her unlawful conduct is or was the product of mental disease or defect. This McNaughton rule, the insanity defense traces in roots back to 1843 when the Englishman Daniel McNaughton shot and killed the secretary of the British Prime Minister, believing that the Prime Minister was conspiring against him. The court acquitted McNaughton by reason of insanity, and he was placed in a mental institution for the rest of his life. However, the case caused a public uproar, and Queen Victoria ordered the court to develop a stricter test for insanity at the time. Also called the right-wrong test, a person was not, like we say now, was not criminally responsible if at the time of the crime he did not know the nature of the act or that it was wrong. The jury was required to answer two questions in this respect. Did the defendant know what he was doing when he committed the crime? Did the defendant understand that his actions were wrong? This test allowed a prosecutor to prove sanity easily by simply showing a defendant understood the moral consequences of an action. Mental illness did not matter. Lastly, the American Law Institute test. Under the ALI test, the defendant must prove by a preponderance of the evidence of the time of the crime because of a mental disorder. He lacked substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of law. This test is more favorable for the defendants because it accuses a defendant of whether his cognitive or volitional capacity was substantially impaired. It does not require complete impairment. The notion that psychiatrists should apply expertise to competence assessment stems from the principle that before allowing a defendant to face criminal prosecution and possible punishment, courts need reasonably assurance-based, if necessary, on careful individualized evaluation that the defendant has adequate mental capacity to make a defense. And also, psychiatrists who provide mental health expertise concerning adjudicative competence give courts information needed to assure that defendants can appropriately protect themselves and that criminal proceedings will be accurate, dignified, and just. Thank you very much.